Welcome everyone to webinar number 2 in our estate planning series on cracking the code and for navigating the complexities of estate planning for blended families. We're delighted to have you with us today. In this session, we'll dive into the essentials of estate planning for a blended family and how it can make a real difference in managing your assets. I am Michael Urch, certified financial planning professional and senior wealth manager at 360 Financial. And today we're going to explore the importance of estate planning and the nuances of a blended family. On our guest panel, we have Andy Lehner as an attorney joining us. He's got expertise in wills, trusts, guardianships, conservatorships, and probate. So he's helping us on the legal side. We have Joe Rapacki, CPA, if you want to wave Joe. That's going to be helping us on the tax side. He's an expert in tax strategy and brings a lot of deep understanding in all the intricacies and changing natures of the tax scene. And then we have Mike Rogers, AIF, joining us as well, president and founder of 360 Financial. With more than 3 decades in the industry and almost 30 years ago, he launched 360 Financial, and we exist to enrich lives. And Mike joins us with a wealth of experience. And you have myself, Michael Urch, as I mentioned, certified financial planning professional. And I have over a decade in the industry helping clients with conversations about all areas of wealth management, including estate planning. And so with all of these professionals on hand, we'll walk through a number of different topics to address blended families. There is a Q&A, and so you should see on the bottom of your screen, I think you'll see the Q&A button, and you can type questions as we go along. Well, we might handle some questions as we go through the presentation, and we have a dedicated time at the end. And hopefully you were able to join us for our first in the series on whether or not you should consider having a trust. If not, we will be sure to include a recording to that presentation in the follow-up from this one. And you'll also receive a recording of this presentation so that you can view it at a later time as well. And also stick around at the end if you'd like to learn more about 360 Financial and the services that we provide and the process that we have for our clients. Stick around for a few extra minutes at the end. Now I'll turn it over to Mike Rogers, president, founder of 360 Financial. Take it away, Mike.
Thank you, Michael. Great introduction. We're looking forward to doing this program today. There's kind of a little heartstring on this one because I do have a blended family, and so I know the importance of planning appropriately with a blended family, and I'm just looking forward to sharing maybe some of the things that I've learned over the years, but really getting Andy's insight, Michael's insight, and Joe's insight into what they've seen over the years as well, so we can share our experiences with you. And what I really hope from the program today is you take some nuggets away that can help you do a better job of either communicating with your family about issues around this, and we'll talk about how you might do that, and how to set up a plan that kind of meets, those conversations. And so Andy will go into a lot of detail about what that might look like. So thank you, all of you, for being on this panel. And, I think the easy place for me to start is kind of the definition of a blended family. And it seems like maybe that definition has changed over the years, but it really hasn't. If you think back to the Brady Bunch and the window panes when all the family members would be looking at each other, that's what I'm living. I've got 6 kids, 3 boys, 3 girls. We are the Brady Bunch. We even had a Brady Bunch themed Christmas card one year that went out to all of our friends and family. And so the description or definition of a blended family is typically refers to a family unit where one or both parties in a relationship have children from previous relationships. Pretty straightforward, right? So this can include step parents. So again, we talked about sandwich generation from sometimes. That could be a potential issue there. Step siblings and step children, of course, and half siblings, creating this kind of diverse family dynamic that requires a lot of careful navigation around conversations on, the complexities of these issues that people have in the estate plan. So as we look at some of these complexities, with blended families. Um, and we find frequently they're much more complex than traditional families, for a better word. So we'll use traditional and blended again. That's it's just just a definition that we use to try to segment what we're talking about today. So the first thing we look at are the different stakeholders as we have here in 2/1, and obviously with blended families, you have biological children that you have to be concerned about planning with. You have stepchildren, and you might even possibly have ex-spouses that are involved. Sometimes that really becomes an issue when you have the conversations of guardianship and what you might want to have happen versus what legally can happen. And again, Andy can reference that as we get a little bit further into it. You know, each group is probably going to have different emotional ties, different expectations, and those differences can complicate matters, especially when it comes to the decision making regarding certain areas around inheritance laws and inheritance generally. Okay. So when you look at the bullet point number 2, and we talk about inheritance laws, again, we'll go into that a little bit, but those laws can make your wishes either hard to carry through or at the very least more complicated based on your decisions and your wishes. So as we're kind of going through this, there's lots of things that we have to understand, and the unique challenges that come up with the blended family is balancing different interests, and I don't mean interest rates in this case. I do mean interest by different family members as far as what they expect, both on the, if you will, the biological side and the step side of the family tree. And how do you communicate those? And that leads to this distribution of these assets. Eventually, how do they get fairly divided? Is it, and fairly is a term that nobody really knows what that means. So we'll talk a little bit about how we maybe put some definition around that. Of course, when you have minor children involved, like the picture on the screen here, guardianship becomes an issue for those minor children. And how do you reference and handle those, especially in the issue of a step parent's roles and responsibilities, if God forbid something would happen to one of the spouses, and or the ex-spouse's role when it comes to that area. And then, then we have the legal considerations. Different jurisdictions have different rules around inheriting assets, whether it's biologically or from stepchild. And the one thing that is crucial, and that's why we're putting on this program, is having a plan. Because without a doubt, because of the complexities, if you don't have a plan, the emotional dynamics really become an issue for families, and frankly can layer in to a family dynamic for years. And that's why it's so crucial to have a plan set up for situations like this one. So I think I've covered that aspect of it. A couple other things that I'll just talk about generally is when we look at these unique challenges a little bit more in detail. I know I'm doing a lot of talking, so panel, if you have any insight that I'm missing, let me know. But when it comes to some, oops, we didn't want to go back to that page. The one thing we have to keep in mind is these nuanced approach. Every blended family, just like every non-blended family, is unique. And the estate plan has to really be tailored to those individual family needs, even more so maybe in a blended family situation. Then of course we have the legal considerations that we referenced a little bit earlier. But what sometimes people forget about are the legal considerations around old documents that might be hanging around. So we'll talk a little bit about that, and how do old wills or existing wills and existing trust that might have been set up previously, how do those legal considerations get addressed under new wills and new trust? And then, again, determining how distributions are kind of allocated among everybody. Um, and when do those get allocated? That's another decision and aspect that we have to take into consideration. Of course, you don't want minor children inheriting assets. They can't, really, but when can they? And is 18 a good age? Is 30 a good age? And how does a surviving spouse, if it's a situation like that, make sure that those assets are usable for him or her as well? And talked about the impact of the family dynamics. I'm going to kind of circle back to some of these things, but it's going to be really important just to have open dialogues that really address a lot of the emotional considerations of each person in the family as they're older. Maybe not as much when they're younger, when they're minors, but especially when you have adult children, to navigate those emotional um, issues within a blended family, where you might be addressing things like the feeling of favoritism, the feeling of jealousy, the feeling of being excluded, all very, very important aspects, especially as the role of the custodial parents kind of supporting this conversation so that the children, especially when they're younger, feel that they're being supported in a longer term, thoughtful, loving manner. And and then you kind of put into place do estate planning documents like trust and other areas that Andy will get into help along with these family dynamics. And then the last one here that we think is crucial is this professional guidance. That's why we're putting this on. That's why we have the tax expert. That's why I have the certified financial planning expert. That's why we have the attorney expert. And then you have me chirping in every now and then. Been doing this for 30 years. So um, with that, lots of things for us to consider. And so I'm going to hand it over to Andy and to Joe, and Michael and I will bring some insight as well, but discuss the tips for estate planning for family members.
Yeah, thanks, Mike. So happy to be here. And of course, I was just thinking, you said a decade of experience for you, Michael, in financial planning. I was just thinking about it. I guess my legal career can vote now. It's 18 years old. So I've been at it a little while too, and I've seen a few different family situations. But yeah, the tips for planning with blended families are notable, right? Because whenever you're putting together a plan, you're making decisions. And you're making decisions about what you want to happen after you're gone, who you want in the driver's seat, what are your values, and you want your documents to come through with that. And as soon as you merge a couple of families together, you've got some new issues that kind of stack on top of that a little bit, and they merit some thought and some communication. So some of these bullet points on this slide are exactly right. And depending on the family situation, different combination of these tools are going to rise above some of the others. But the transparency and communication within the family is, to me, kind of a big deal. And I think that starts, and this is sort of obvious, but with the spouses. And here's what I mean to be a little bit more specific. I've had the experience of sitting with, relatively newly married couples who both had, previous relationships and in many cases children and disproportionate wealth. And we sit down at this table because they want to do this. They want to put together a thoughtful plan. But in reality, they haven't necessarily been fully transparent with each other up until then. And I don't mean that to say they're keeping secrets per se, but they just haven't opened the door to that conversation. You know what I mean? And that is an essential first step. A lot of times that can be done even before, well, ideally from my perspective, before you're sitting in my conference room, because I don't necessarily want to be that kind of counselor. I want to be a legal counselor, but having those conversations at the outset is sort of an obvious and important first step from my perspective. And from
So
that,
you're not a marriage counselor. Is that what I'm hearing, Andy? Is
no,
that
I study psychology, but that's not really my jam.
Okay. Just want to clarify that, So
They call lawyers counselors, but not like that.
yeah.
Um, Yeah, so I mean, and then once you start from that foundation, I would say then, a lot of these other bullet points kind of start to fall into line. Where are your values? Who do you want in the driver's seat? What guidance do you want to give them? What discretion do you want to give them? And we're going to get into it a little bit more, I know, so I can maybe leave it at that for now. But that's just from the legal, like, planning perspective, right? But you kind of have to do that before you can start down this path, is kind of my initial point.
Hmm. So do you think from the standpoint when you look at some of the other bullet points that are in here as far as choosing a trust over a will and that sort of thing, is that part of, what you want to talk about now, or do you feel like you'll do a little deeper dive as we go a couple more slides in?
Yeah, I mean, I think maybe these will unfold as we go. But these are definitely options. There are situations, and you pointed some of them out earlier, Mike, like where you've got maybe minor kids or children with special needs, or maybe children from, different relationships that are really different in age. Trusts are really great for, spanning gaps and for giving particular guidance, but that's not the case for every family. Maybe wills are more appropriate. And sometimes it's a mixture of both, but it's really fact specific. So I would say, yeah, for the purposes of this outset, maybe let's keep going. And I think we're going to get into it a little bit as we go.
Okay. Okay. Um, could we definitely will do that. I have one question on the because it does come up on the power of attorney and the medical
Yeah.
directives. You know, again, with estate planning, a lot of times we go down the path of kind of worst case scenario, of course, but the medical directives is really crucial, isn't it? Because that can create quite the family, let's put it this way, dynamic, emotional dynamic if one of the parents has got a medical issue,
Oh,
especially if it's in a medical emergency. So
right.
if
Yeah, and that's right. And this is part of that conversation, right? Spouses come together and like, how are we going to do this? How are we going to make this work? And part of it is forward looking like that, right? Because medical directives and powers of attorney, those are both incapacity planning tools, which means they're for the case when, the person who's having, who's in need of help is still living. They're not deceased, but they're maybe not able to make these informed decisions and who should step in and advocate for them. You might have an adult child with pretty different views from their step parent, right? The spouse. So yeah,
Mhm.
spelling these things out are critically important.
Okay. And I know we're going to get into it, but could you just quickly talk about what's a no contest
Oh,
clause?
yeah, so if you want to go down a rabbit hole on the internet, you can look up Frank Sinatra's will. He was famous for this one, right? But basically, a clause saying, look, I'm going to make a provision in my will for you, family members. And if anybody has a problem with the thing that I'm giving you and you bring some sort of contest, we're going to sort of cut you out or give you some reduced amount or something like that. It's a way to try to quell the possibility of people bringing forward their challenges and disincentivize it is essentially the idea.
Hmm.
Yeah, so it's a protective provision. And, in a blended family where, maybe you've got, you're merging households, who knows, how far we've gone and how well we're operating together and how much trust or distrust there might be. These are important potential tools to include in your document in that scenario.
Exactly. Exactly. Okay. Good. That's a good overview. I know we've got a lot to cover. Joe, from a tax standpoint, I know again we have some things to cover coming up for you, but is there anything on here that pops out to you as an issue from a tax perspective?
Not really at this time, but
Okay.
I think planning is so important because you never know when someone's going to pass away. And I've had one client who's she got married and a month later her spouse passed away, and there was an extended family, and she was very accommodating to the family where she didn't need to be. So it could have really been ugly. But
Mm-hmm.
yeah, so.
Yep. We got to keep everybody happy, like the picture on this screen where they're all walking to the beach, I'm guessing. So that's the goal, isn't it? Okay. So let's dig a little bit into into maybe some of the legal and maybe even tax considerations. But we've got a few different areas here of communication and distribution and kind of legal and financial considerations. So um, three of you guys can pull this apart and then speak to each, I'm sure.
Mhm. Yeah, I mean, I can jump in a little bit. I mean, I talked about the open communication kind of at the outset, particularly between the key people in this relationship, mom and dad, most likely, right? And guiding some of that. I'm guessing maybe you, Michael, as you're meeting with blended families, this is something that you probably dive into early on, I'm guessing, as you plan.
Yeah, absolutely. And I think one of the things that's very helpful is if you could sit down with your spouse and just talk through what the two of you would like to happen under different scenarios and really iron that out to some extent. And that's something that I'm often part of that conversation with clients as well. A lot of the times, I think that people come to the estate planning conversation saying, what estate planning tools do I need to use? But especially with a blended family, I think the best place to start is what would you like to happen? And let's
Right.
really start the conversation with clear communication among you and your spouse and other family members about what you'd like to happen. And then we can sit down with Andy or another attorney and say, well, here's what we'd like to happen. What are the legal um, solutions that can help solve for what we want to solve for?
Yep, absolutely. That open communication piece is vital, right? So if both parents, if the spouses, if you will, the married couple, what are on the same page, it makes the whole planning process for everybody a lot smoother. You know?
On this idea of fair distribution and asset protection, I would say that defining what fair means, you sort of alluded to that earlier, Mike. Like fair by
Mhm.
what standard? What does fair look like? And it's a conversation for folks to have, but getting that on the table at the outset so you know where you're going and how to apply the tools to accomplish the result. That's really important. And this idea of protection, a really common thing in a blended family when we're looking at an estate planning technique is what do we do with a surviving spouse after the first death? Are there provisions exclusively for the surviving spouse, and we make their children, who are maybe not the children of the surviving spouse, wait for any inheritance until after the death of the survivor? Or do you want those assets to go some straight to the children, especially if they're adult children, or some mixture of those two things? But this idea of asset protection is another big topic, and it's something for couples to have sort of at the outset. So you have big picture concepts. And once you have the big picture idea, we can hone in on it as we craft documents and planning tools. But this idea of fair and teasing that out is important. And then deciding how much you want after a first death, how much you want to leave in the hands exclusively of the spouse versus the children of the spouse who died first, or some blend of that. These are kind of big picture things that are important, again, at the outset.
Mhm. Yeah,
And maybe not
especially,
easy and intuitive for some people either.
yeah, yeah, and kind of gets back to more communications. I mean, you can, as an attorney, you can draft all the right documents
Right.
to get them to that point, whether that's a combination of wills, trusts, prenuptial agreements, postnuptial agreements, whatever it is that seems to fit. You can also keep assets separate, to kind of get you to some of that. I'm specifically thinking of IRAs that a spouse might bring into the relationship. Maybe they want that IRA to go directly to their biological children. Well, that's a fairly easy planning tool. But if you don't have the conversation around what I want to have happen to an asset, like an IRA account, then it creates more conflicts for down the road. Mm. And the regular review part, the last bullet point right there in the middle, is probably one of the most crucial points because life changes, and so as life changes, the plan needs to change with it frequently.
Right. I would say that, legal documents, they can go out of date because of the scenario that you find yourself in, but they don't expire by the mere passage of time,
Yeah.
which means your old plans are going to continue to be your current plans unless you address them, which is sort of obvious, but to emphasize the point, right?
Yeah, that is a good point. And it kind of leads right into this legal and financial considerations, that you have to take into consideration. And again, professional guidance along these lines help. But can you, address, like, for example, Andy, state laws, that could be different from state to state.
Yeah, I mean, I'm licensed in Minnesota and Wisconsin, and they're very different on the topic of marital assets and how they're treated. So yeah, paying attention to that is also very important. And you know, in that last category, on top of the stuff I'm talking about that are particular to blended families, like how do we treat a surviving spouse that's not also the parent of some surviving children? You know, how do we relate those two like people that both had a relationship with the decedent? Then there's the layer of, and if they're minors, what then? You know, and putting in protective trusts for that and considering all the while any estate tax or other implications and coordinating it. It can be a little bit complex, but having, you know, getting it on the table now is an opportunity to deal with it well, and not wait for something to happen with results that you weren't expecting.
Mm-hmm. Yeah, when you look at, especially going into Joe's expertise, when you look at the tax implications, that can be even more compounded if you have a higher, estate plan that's worth 3 million or maybe $6 million in the state of Minnesota. You might not be as impacted, than Wisconsin, or if you're a Florida resident, for example.
Right. And also, even when the spouses are both living, there's issues with how to assign who owes what tax, or who's in the couple, which one has the tax liability, and how do you treat that? Do you use one spouse's assets versus the other? So even in the normal filing, it can get complicated with a blended family. So
Yeah, that's a great point, because that comes up every April 15th, in certain cases, right?
yeah.
Okay. All right. So good overview as far as how to navigate some of these areas. Let's do a little bit of dive into just some, what I going to get a kick out of is some case studies that we're going to talk about. But before we get to that, just, maybe get in a little bit into the different types of trust that blended families might be using, and give us some overview there, Andy.
Yeah, so trusts are certainly tools that are useful in potentially any planning scenario, but they could be particularly useful in blended families. The way I view trusts in this area are they are entities that can exist after somebody's life to accomplish a purpose, right? Until we've reached another side. They're almost like bridges from one event to another event. And during that time, something like a trust can make provisions for a young person until they reach a later age, or can make income and support provisions for a surviving spouse for their lifetime before the principal of that trust is ultimately distributed to maybe their stepchildren later on, or any variety of tools. But they can be like a bridge between goals, I guess is a way to think about it. There's lots of different kinds of trusts. They may or may not be applicable to different situations. Revocable trusts are highly flexible, but they offer lower amounts of sort of protection or assurance because they are malleable, they're changeable and revocable. Whereas irrevocable trusts, they're protective type trusts, where if I, am in a blended family and I want to make sure my spouse is provided for the rest of my spouse's life, I might create an irrevocable trust to be created after I'm gone to complete that purpose, even after I'm gone. And then I can say, when my spouse subsequently passes away or remarries or some other event happens, then we're gonna do something else with this. So irrevocable trusts can be critically important in a blended family. Testamentary trusts are trusts that are just created after someone's death. Usually those spring out of a will. And that could be a useful tool potentially too. A lot of times we see those for young people. And special needs trusts are more designed for, families that have family members with disabilities and making sure they get the support they need without upsetting their eligibility for benefits. But lots of trust tools in the toolbox, and depending on the situation, we'll get out the right tools to get to the right result.
Yeah, and from the standpoint, sometimes it is, just a matter of making sure that, when you're looking at these different trusts, again, that you're building a trust strategy. Just like you said, Andy, not every trust is needed by every blended family. So it's
Right.
just a matter of which one makes the most sense, or ones, additional, maybe 2 of them or 3 of them, depending on your particular situation. I know I've had clients, with blended families that have had needs for special needs trust,
Yeah.
and that can be a very burdensome scenario for a family. But if it's addressed right up in the front side of it, and how to care for somebody that falls under this, umbrella of the special needs trust, it makes a world of difference, I think, in that relationship, and just removing the what ifs. What if something happens to me? What would happen to, that the person that has the special needs? It's very important. You
Absolutely.
um,
One,
go ahead, Michael.
yeah, one very common desire that I see is that someone says, okay, I want my spouse to be taken care of for their lifetime if something happens to me, but I would like my biological children to receive what's left of my assets after my spouse passes away. And if you just have your spouse listed as a transfer on death or as a direct beneficiary, you don't have the ability to control that. But a trust is a great mechanism to be able to set up that desire in a legal way to make sure that it's actually able to happen the way you'd like.
And that's a different type of trust. I would assume, Andy, isn't that the Q-tip trust frequently that would kind of drive that
Yeah.
sort of outcome?
Yep, that's a common name. So Q-tip being qualified terminable interest property, but it's designed to avail yourself the benefits of like a marital type trust for income tax purposes, but still having the principle of the trust preserved for the benefit of other beneficiaries later on. But yeah, that's right. That's one of the tools.
Mm-hmm. See, another lawyer. I just play one on the webinar, right? Yeah. So, all right. So that kind of gives us an overview of some different trusts that are, if you will, available. Could we, and maybe the three of you, especially for estates over $3 million, but in this state, could you go into some of these questions, and then we can get into a little bit of some, if you will, some examples or case studies, if you will.
Sure. Yeah, I mean, I feel like I keep saying kind of the same thing, but these are really fact specific. So these things to me are not necessarily a checklist for everybody, per se, but they are like topics to kick around and discuss and see how they might apply in your situation. But when I see gifts for children, one of the things I think of is, if you've got adult children in a blended family, part of your estate planning tools might make a provision for them on the first death if it's their parent who goes first. Or there might be some lifetime gifts to bring some equity and coordinate that with the estate plan for after they're gone. And we just talked a little bit about that second bullet point about if one spouse dies, does it simply go to the surviving spouse, period? And then presumably predeceased spouse is trusting surviving spouse to do the right thing after they're gone, but there's no, way to enforce that, or just trust with a lowercase t, trusting them to do the right thing, as opposed to this lifetime limitation of saying, hey, you get to enjoy this as you might need it for your lifetime, but you can't just take the money and run. And when you're gone, whatever remains is going to the kids. And the idea of commingling versus keeping separate, these are all important topics. And
Mm-hmm.
the pre and post-nuptial agreements are very much in line with that. So these are all upfront, like big picture things to put on the table at the outset to see where you want to get to on these topics.
So with these topics, let's jump into this scenario that we have with the Smith family. That is a blended family, remarriage, or with minor children from previous relationships, and talk about, maybe some strategies that we would want to look at for, this sort of environment.
Michael, how would you start with the Smiths?
Yeah, I think one of the big questions is what assets did each of them bring into the relationship before they were married? And how do we want those assets to be treated? And so we can keep them, and we can have them be essentially marital assets or try to keep them more separate. But I think that's an essential question to really understand. And something that I see often is they might create a joint investment account, for example, without necessarily thinking through the impact of having that joint investment account, because then if whoever dies first, the other spouse would automatically receive full ownership, sort of like with the beneficiary situation I was talking about earlier. And so one of the first questions is, how are all these assets broken up? And really understanding that net worth and understanding what belongs to whom from before the marriage and what belongs to both within the marriage. And that's when you can start to get into the deeper questions of, so this is how your net worth breaks out. If something happens to either of you, what would you like to happen? And so just as an example, from an attorney standpoint, Andy, if someone said that they, care about the impact on their children inheriting money, if their children go through a divorce,
Mhm.
how would you talk about some
You're,
potential legal planning you could do
you're
there?
saying like an adult child who's married themselves and planning for their future potential situation?
Yeah, and this is something where when someone's been through a divorce and remarriage, I think they're especially mindful of their
Got it.
children inheriting assets.
Yeah,
And if
yeah.
there's a divorce and remarriage, and would love to have you just talk to that piece of the planning as well.
Well, on the topic of separate versus commingled assets, a lot of times by the time I sit down with folks, they've decided how they want to do this. Whether they're going to put everything into joint accounts or some things in joint accounts or nothing in joint accounts and keep everything separate. But from the perspective of a future dissolution, or divorce, whether you keep something separate or whether you commingle it matters. I'm not a family law attorney. I don't help people through the divorce process, but I know enough about it to know that that is important. And so having that conversation at the outset is critical for that reason. You could also, in your plan, and I think this is what you were getting at a little bit, Michael, is maybe even leave instructions in your documents to say, hey, and if you inherit this money, you should keep it in a separate account. Call it the inheritance account and leave it as yours alone. And you can use it and enjoy it however you want, including for, to enjoy with your spouse. But in the future, if there is a divorce and that asset comes onto the table, it's clearly been kept separate as a inherited account, right? Or as an account that's not commingled. Because once you commingle something, extracting it again is not so easy to do, especially if years go by. So yeah, that's right. That's actually a really good point when you sit down with people having that conversation. And I've certainly sat with people who have not had that conversation, and it's tricky, right?
Mhm.
So I appreciate having that in order. You need good advisors at the outset, you guys. Do your clients know
Absolutely.
that?
That's crucial, isn't it? And with the Smiths here, it's maybe a little more straightforward than a couple other scenarios we're going to take a look at where they are, if they're in a spot where they're like, okay, let's just treat all the kids equally out of this relationship. If anything would happen in this picture, they're a relatively young couple with relatively young children. So some of the issues that they're going to face could be drastically different, but they're coming in roughly with our same amount of assets. They're probably their biggest concern is something would happen to them that these wonderful smiling kids would end up with the funds, and I'm assuming guardianship and everything else out of the off to the side, that what you're looking here is some trust work, is make sure that we have these distribution of these assets to these children pretty well defined.
Yeah,
Yeah.
looking at the young faces for the Smiths. That's
Yep.
right. There's probably trusts, at least testamentary trusts, if not revocable trusts, that are going to do that. That are going to protect the young people to a later age, right? So they don't blow it. But also the guardian nominations, just a little bit more on that with minors. Parents can nominate guardians for their minors in their will. That's pretty common. But in a blended family, a lot of times one, one biological parent is in this household, and perhaps there's another one in a different household, and a guardian nomination in your will doesn't supersede parental rights, right? So if there was a death of a spouse, the surviving spouse would have priority to serve as guardian for that child, even over the nomination of the spouse who died first. But if the other spouse is out of the picture because they're deceased themselves, or if parental rights were severed, then that guardian nomination is really essential. And then in a blended family, maybe we've got children from other relationships. Maybe we also have children in the household that are a product of this relationship. And so there's going to be different types of guardian nominations, but they're all things to walk through, and it's fact specific, but it's all part of it. That's right.
Yep. Yeah, that kind of you're jumping ahead of me. We got a
Oh,
little bit
sorry.
of no, you're good. You're good. We've got the Johnson family here. Now this is a classic Minnesota name with the Johnsons. And in this case we have, remarried couple with adult children. So a little bit different scenario from previous relationships. And what we have here at our scenarios, we have Rob and Rebecca Johnson, and Rebecca brings substantial inherited assets into this new marriage, and they want to take care of each other, which is typical, without disinheriting their own, again, biological children. Not specifically just making sure all the assets go to them, but making sure that they are taking care of the children from the previous relationship. So what might be some strategies that we would use with this family? Even here, we're looking at probably in this picture, if you will, grandkids involved as well. But let's just stay with the one generation planning with the adult children.
Yeah, I mean, this family scenario to me looks like something where we're likely looking at an irrevocable type trust after the first death, particularly if Rob survives Rebecca, right? Because if their goal is to provide for the surviving spouse, they probably want to make sure that those assets are available. But if it was disproportionate, I mean, when we see, one bringing substantial assets, I guess that assumes the other one brought less substantial assets. So if it's disproportionate wealth, a lot of times using an irrevocable trust is really good at sort of both protecting and providing for a surviving spouse after the first death, but still sort of honoring the assets that came from this side of the family and keeping them on this side of the family. And so you can do it both ways, but it does require some affirmative planning, right?
Mm-hmm. Yeah, I think when you get into I've seen this a lot of times where in a remarried environment, what ends up happening is because they're coming from different life experiences, different areas, the different levels of wealth. Some might be in a position where they are inheriting a substantial amount of money from their parents, and so in this case, you might have where the parent of Rebecca, for example, wanted to make sure that Rebecca inherits the assets, but also Rebecca's biological kids inherit the assets, afterwards. So any thought around that, Andy, from a planning perspective?
Yeah, I mean, it depends on what you want to accomplish at the end of the day, right? I mean, if you do want to keep the disproportionate wealth by family lines, then yeah, we can craft tools to certainly do that. But we talked earlier about this idea of, equity and fairness. And depending on what Rob and Rebecca decide, maybe they decide they want to treat all the kids equally, at the end of the day, regardless of which family they're from. It's kind of up to them how they want to do it, but then we'd apply the tools accordingly. So yeah, I have more questions for Rob and Rebecca.
Yeah.
Before I can tell them what they should do.
Yeah. I think one of the first questions that I would have is what exactly is the estate value for each of them? Because in some cases, inherited assets are in some sort of irrevocable trust that has its own definitions for what the money can be used for. Yep. And so if it's Rebecca's outright and she owns it in her estate, that brings up different options than if it's outside of her estate. And then we get into a question of, are we running into more than 3 million Minnesota estate tax exclusion, more than the federal estate tax exclusion, and you start layering broader estate planning on top of the blended family. And it really is something where most of the thinking is about asking the right questions to start with before you really get into being able to draw up some good solutions.
Mm-hmm. Yep, absolutely. I would agree with that. And from a tax standpoint too, Joe, if we have these different types of trust and we have irrevocable trust and we have, let's say, deceased parents, or in this case, the grandparents of these younger kids. You might even have trust returns that have to be done for certain areas as well, wouldn't you? When
For
you're,
sure.
again, looking at how this would work.
Yeah, yeah. No, we frequently see trusts where, the kids are beneficiaries and of the grandparents or whatever, and that works pretty well. It does work pretty well.
Mhm.
And one question, Andy, do you see people, some couples just not getting married to avoid all this?
Yeah.
Do you run across that too?
Yeah, sometimes.
Mhm.
I have one couple in particular that I'm thinking of on that topic where, well, her profession is in the financial industry, and so she maybe has a little bit more of an insight than the average Joe. But she basically said, "Look, I'm receiving survivor's benefits from my first spouse who passed away, and if I get married, it's going to upset our budget, and so we're just choosing not to do it." And that's their reason in that case. But there are also other situations, maybe with a family business or maybe with disproportionate wealth where they are still going to be committed to one another, but are electing not marriage for that reason. I do see that.
Yeah.
Mhm.
And there's
Yeah.
probably some income tax consideration. I mean, I know there are income tax considerations to that too.
Yeah. No, you're right. Yeah, I see that once in a while too. And it's, I don't know. It's hard to maintain that kind of relationship where you're married, but you're really not, or you're not married, but you're kind of acting that way. Yeah.
Now we're back to the beginning about all those early conversations and being transparent about how we're going to go about this and just being upfront about it. But yeah, you're right. That's not tenable for some people.
Yeah. Yeah, it just gets, more and more along the lines of just having a conversation, doesn't it? So, oops, with that in mind, I'm sorry, skip past this one. Let's look at one more example of a family. Here's the Garcia family. So we have Chris Garcia has an adult child from a previous marriage, and Chris and Elise here also have two minor children together. So now that creates another dynamic when you're looking at significant assets, especially in this case. You mentioned it earlier, Andy, where there might be a business involved. That in this example, Elise brings the business into the family, and how does that potentially get handled?
Yeah, well, from the business perspective, it really depends on the type of business it is and how it operates and how it should operate going forward. But a lot of times there's governing instruments for that business, some sort of articles of incorporation or LLC agreement, operating agreement. And sometimes those dictate how the business will pass, and it's almost outside of a will or a trust in an estate plan, but sometimes not, right? And if that's the case, we can craft ownership interests and even in some cases business operating instructions even within a trust. Even as I say it, I think, I don't know if I would advise that. You might want to talk to a business attorney, but there are considerations, especially if it's a family business. It's important that it stays in the family. There should be plans laid, whether it's in wills or trusts or whether it's in operating agreements. One way or another, you want to preserve that. So that thread is one thing. But then the other thing that I see for the Garcias is we've got one child who's an adult and two children that are minors. So as far as guardian nominations, we've got both parents in the marriage making a unified guardian nomination. That works out pretty slick. And we don't have to worry about it for the adult child. But then from an inheriting perspective, the theory might go, well, adult child only has one biological parent in this marriage, which suggests there's another biological parent out there who might also make some provisions for her in their estate plan. And if that's the case, do we proportionally increase the amount for the young beneficiaries because they don't have an outside parent somewhere? They only have the parents in this relationship. But just talking through those considerations, and this is where you tease out a little bit more. Well, what do you mean by fair? Is fair in this family that all three of them get the equal amount, even though one of them has another parent somewhere that might be making provisions for her, or not?
Yep.
But you got to have the conversation before we know
Yep.
how to make your documents.
Yeah, so the point is every one of these scenarios really are unique, and every one of these scenarios need to be built around, what are we trying to accomplish, right? So, if we're not specifically focusing on the unique family dynamics, you're probably going to end up with a plan that doesn't meet those unique family dynamics. So we need to really create these open lines of communication, highlight the importance of estate planning with your family members, try to foster transparency and understanding, and the reason you do that is to avoid conflicts for down the road. And I've been doing this long enough where I've seen those conflicts, and they happen, unfortunately, more frequently than you would hope as an advisor to those families. So again, the leveraging of advisors like myself, Michael, Andy and Joe, and whoever else is in your network of professionals, really is pretty crucial. Then try to figure out through this relationship and through this open communication, what is fair. Encourage, family members to maybe, give their opinion of what is fair. You might be surprised, what they say, both positively and negatively. But the goal is to really try to empower this future generation to be part of the conversation so that they can feel a sense of responsibility to this as well. And I think if you can do that, you end up with a much better outcome for family happiness after one or two of the parents have passed. So here's a couple of quick tips. I think we've kind of gotten to a lot of this already, but really, involve all the relevant partners. All the stakeholders, if you will. Try to compile a list of individuals who should be involved in the process. Don't leave anybody off the list unless it's by design, not by accident. Invite the participants. Literally send out an invitation to a family meeting would be the way that I would approach it, and communicate kind of the importance of this meeting and this conversation. And if we can do this in a collective, collaborative planning approach, you're probably going to end up with a lot better outcomes than you will. And don't forget, part of the process is to solicit, feedback, to listen, and to each other within this meeting, and really try to focus on, the end goal. And the end goal for most of our clients is, I just want to make sure that my family is taken care of and they're not fighting about it when I've left. That's really what it comes down to at the end of the plan, right? So, we all of us on the panel are happy to work with you on these areas. These family dynamics are something that we have done and addressed in the past, and we continue to do so. But even here at 360, one thing that we've done is, again, these family meetings. So we can help you with that. Andy can help you with that. Joe can help, especially on the tax side of the ramifications of certain decisions and what does that mean as far as the future tax work. But we can get into a scenario where, as a team, we probably address all of your needs and make sure that we can all sit around this Thanksgiving table with some smiles on your face, instead of a lot of disgruntled family members. That's what we hope.
Looking at these pictures makes it look like a really good time to work with your financial advisor and your CPA and your attorney. So that's what I'm taking away.
Isn't that the truth? Yeah. So, from the standpoint, a couple of things, Michael, maybe you want to bring us home. I know that there's some questions that have come in.
Yeah. We have one question I want to make sure to speak to, and Andy, I think you'll be most helpful here. So we have someone that has purchased a second home in Texas. They have a home in Minnesota that's within what I think sounds like a revocable trust, and they loaned against the Minnesota home that's trust owned, and they're asking, does the home in Texas automatically go on the trust for the Alexandria home? And so hopefully that's enough of a question for you to be able to
Yeah,
answer. It's
there's
very
some
specific.
there's some really specific particulars in here that I feel like I would have to clarify to give you a good answer. So I don't know who sent this, but I would be happy to dialogue in an email to get a little more particular. But I will say this, with with trust owned property, the trust that owns the property is going to dictate pretty much the answer to your questions about what you can and cannot do. And you're going to have to look closely at the trust in order to get good answers for that. The second thing that I would say in response is that this second home that was purchased never automatically goes into any trust. You have to manually put it into a trust if it's going to go there. So it's not going to happen without you knowing it, right? So there's not anything automatic about it. And that's my quick knee jerk to that question without getting more clarification and having more conversation about it. I hope that's at least a little helpful.
So in other words, give you a call, but at least that gives you a little bit of clarity to it. Joe, was there something you were going to bring up?
No, and well, I guess Andy, well, Wisconsin, anything really special about Wisconsin we should know?
Well, I'm a Wisconsin native, Joe. I think there's a lot of special things about Wisconsin. But from a planning perspective, for the most part, the tools work a little bit differently and the defaults are set up a little bit differently in a default family. And it's important to know that there are key differences, I would say, for the purposes of a program like this one. But whatever your ultimate, decision might be on how you want to keep things commingled or separate or what result you want to achieve, there might be slightly different ways to apply the legal tools to accomplish those goals because there are different rules in those different jurisdictions.
Okay. Yeah. Right. Well, thanks, Andy.
Yeah.
So Andy, I've got another question that popped up here. I was just curious about. How about as an asset, life insurance proceeds, and how do you potentially handle those differently?
Yeah, I know we're up against the clock a little bit, but I have a number of things I can say about that. So with life insurance, number one, sometimes in a blended family, we have one or more of the spouses who were previously divorced. And a lot of times divorce decrees make provisions for life insurance, especially if there are young beneficiaries. And those are not optional as far as how you move them and create them. And depending on how the divorce decree was written, you might be able to shift some of those insurance death benefits over time as the children get closer to adulthood, away from the obligations of that dissolution agreement and more towards your manual control. But you really do have to be cognizant of that in a blended family. I don't know if that's what your thought process was in asking that, Mike. But
Well, that's definitely one of them. I don't know if I think maybe it's more of I've got some life insurance on my life. Where do I put that as the benefit? And again, I know it's a detailed question and answer thing, but do I put that as my spouse as the beneficiary? Do I put it as the kids as the beneficiary? Do I put it as a trust as a beneficiary, or what kind of trust? I mean, those are all kinds of questions I know we don't have time for, but what would you
But I would say the answer to that's going to come from your initial sort of free decision making about what goal you want to accomplish. So if your goal primarily is to provide for your surviving spouse after you're gone, you're probably going to name a trust as the beneficiary of that policy, because then in the trust, you can say, hey, I want this to provide for my spouse in this way for the rest of my spouse's life. And then after my spouse is gone, I want it to do this other thing. Or if your goal was this was just a one-off to provide only for my biological children, maybe you name them directly if they're adults. Or if they're not adults, maybe you have a separate trust share for them for your own purposes with your own guidelines. So the answer is it really depends on what you want to do with that insurance policy, but it could be a variety of different things.
Yeah, those are all good points, for sure. I know we're running up against time, but is there maybe one last question that's either come in from the participants, Michael, or that we have here as a panel?
I'll ask one more question for Joe. Some trusts have to file their own tax return, and how are trust tax rates different than personal tax rates? And that's something we think about a lot when we have money invested. Is the difference in tax rates. But could you speak toward that?
Yeah, so if there are dollars sitting in the trust, they're going to be treated differently from personal returns, right, Joe?
Yeah, much higher tax rate for trusts. It gets to the higher rates very quickly. So that's why everybody tends to distribute the income to beneficiaries rather than keep it in the trust, if at all possible. Yeah. So
but while the trustees are alive and maybe the assets are just in the name of a trust, you don't have a separate tax return for that, if I'm being clear, I think.
Not if it's a revocable trust.
Right.
If it's an irrevocable trust, it gets to do its own tax return.
That's true. Yep. Thank you. Yep. Yep. And yeah, that brings up some more questions I know people will be asking, but we'll kind of leave it at that for episode number 2 of Cracking the Estate Planning Code. We have number 3 coming up. Michael, you want to give a little teaser to what that might be?
Number 3 is all about estate planning for high net worth families, especially if you're getting past the federal estate tax exclusion. And so I think we'll have some really good information there. Also, thank you everyone who attended today. Andy is available to meet for a no-charge initial consultation. If you have any follow-up questions for an attorney, Mike and I and others on the 360 team are available to meet within again, complimentary 30 minutes to an hour, just to talk through any follow-up questions that you might have. And Joe also is available on the tax front. And so I want to make sure that you're able to take advantage of us as far as what we're offering, and that you know that we're really here to answer any questions that you have if we didn't get to them today.
Right.
Good. So thank you, Michael. Thank you, Andy. Thank you, Joe. This is incredibly helpful, I know, to people who have all kinds of questions. Hopefully we at least have laid the groundwork on what you need to do inside of the blended family scenario so that you can accommodate every member of that family according to the way that you want it to look upon your passing. So thank you. Important topic.
All right. Good.
A couple things here at the end that I'll just bring up. There's a couple of disclosures, as far as, investment disclosures. We didn't talk today about investments, but since we hosted this program, we had to bring that up. And then for some of you on the call who are not utilizing our services as a wealth management firm, I thought it'd just be very quick, an overview of how we work with people and why this estate planning is so important to us. And so I'm going to cover our Venn diagram that really explains the core of our process here at 360 Financial. And the core of the process is, and you probably have figured it out, what we're trying to do in all of our planning is really drill in on what matters to you. And we've built a nice acronym around this conversation that is family, occupation, recreation, and money is the acronym of FORM. And if we address all of these goals and what you hope to receive from advice on these areas, then we can build a specific plan tailored to your specific needs and include the tax parameters, include the estate parameters, include the insurance parameters, and look at the investments as well, all bundled together into one plan. And then while we're building this out, and maybe it's become even more relevant and post-election here, no matter what side of the aisle you sat on, some people were happy, some people were not happy. I know at the end of the day, what we have to focus on when we're working with our clients is what we can control and not focus on what we can't control. We do know there's going to be policy changes coming up. So how do we control those policy changes, and how do we control our philosophy around our planning process so it's unique? And then when we're focusing in on the planning process, how do we go further into discovering, designing, and deploying a customized plan that really meets your family's specific needs? And we title that area that we can control and what matters most to you into what we call the life wealth plan. And if we can control and plan around these form goals, at the end of the day, clients will have probably successful outcomes, and they'll have a scenario where they can actively address each of the scenarios that we just talked about today when it gets into estate planning or when it gets into investment management. Just as long as we have a structure and a framework around what we're doing. So tax, estate, risk, and investments are the four pillars of wealth management. And we try to bring them all in together around your form goals. So, I mean, that's an overview of kind of how we work here. And one of the reasons why we collectively have come together to bring on these educational programs for our clients and for the people who are not clients yet. So thank you, everybody, for joining us. Michael or Joe, did I miss anything on the overview of our services?
No, I think you're good, Mike. Sounds good to me.
Good. All right. We'll sign you up, Joe. All right.
One final word that I'd have is that we really work hard to provide a team of specialists for our clients. And I think that having that full rounded team, that's why we have this panel here today. And we spend a lot of effort coordinating between the different specialists on the team for our clients. And so, I mean, really, I think it just is a great benefit to our clients to be working with a team of professionals and to have someone to kind of coordinate that on their behalf. And so if that's something that you don't have, would love to set up a conversation just to talk about what that might look like.
You know what? That's a great point. And with that in mind, the one thing I don't think we brought up at the very beginning, but you know, we have our office and location up in Elk River. Brian is the one who runs that office for us. He joined us in the 360 a couple of years ago, and as part of a merger. And Brian isn't on this meeting today because he's enjoying time with his wife, celebrating their anniversary. So we wish him the very best, and I just wanted to point that out in case somebody was wondering why Brian wasn't on the panel. But he'll probably be back for episode number 3.
That's right.
He's in Hawaii, so that's why I say probably be back. But thank you. Thank you, everybody, for joining us. If you have any further questions, feel free to reach out to each one of us. Have a great day.